About indemnification by Chat GPT 3.5. Can you please define indemnification in ordinary words, and also in more nuanced legal terminology? Chat GPT. Certainly, here's the definition of indemnification in both ordinary language and more nuanced legal terminology. In ordinary language, indemnification is a promise made in a contract where one party agrees to protect and compensate the other party if certain problems or losses occur. It's like a safety net, ensuring that one party won't have to bear the financial burden of specific issues covered in the contract. In layman's terms, imagine you're hiring a contractor to work on your house. You agree that if anything goes wrong, like if their work causes damage, they'll fix it and cover the costs. It's like a guarantee that they'll take responsibility for any problems they might cause during the job. In more nuanced legal terminology, indemnification is a contractual arrangement where one party, the indemnitor, assumes the financial responsibility for certain losses, claims, or liabilities incurred by the other party, the indemnitee. It obligates the indemnitor to compensate the indemnitee for specific types of harm or costs, typically arising from defined events or circumstances as outlined in the contract. Indemnification serves to allocate and manage risks between the contracting parties, ensuring that one party is protected from financial harm due to the specified issues covered in the contract. Please draft a very minimalistic and simple indemnification clause. Then give a simple scenario, where, if we did not have any indemnification clause in the contract, the outcome would be radically different than if we had this sample clause in the contract. Chat GPT. Certainly, here's a very minimalistic and simple indemnification clause. Sample minimalistic indemnification clause. Indemnification clause. Party A shall indemnify Party B against any losses, costs, or liabilities arising from Party A's breach of this agreement. Scenario without the indemnification clause. Imagine Party A and Party B enter into a contract for Party A to provide consulting services to Party B's company. The contract lacks an indemnification clause. Scenario: during the course of the consulting project, Party A provides incorrect advice, leading Party B to make a costly business decision that results in significant financial losses. Party B has no legal recourse to recover the losses from Party A because there is no indemnification clause in the contract. In this scenario, without the indemnification clause, Party B has no protection or mechanism for holding Party A responsible for the financial harm caused by their breach of contract. They would bear the full burden of the losses, which can be a substantial financial setback for Party B. If the minimalistic indemnification clause were included in the contract, Party A would be legally obligated to indemnify Party B for the financial losses incurred due to their breach of the contract. This simple clause could make a significant difference in ensuring that Party B is financially protected and has recourse in case of a breach by Party A. In the example above, why does the indemnification clause provide a separate cause of action that is not already existent by virtue of the contractual promises being legally enforceable? Chat GPT. The indemnification clause in the example provides a separate cause of action because it explicitly outlines the obligation for one party to compensate the other in case of losses arising from the breach of the contract. While contractual promises are legally enforceable, the inclusion of an indemnification clause serves several specific purposes. Clarity and emphasis. The indemnification clause makes the indemnitor's commitment to compensate the indemnitee for specific types of losses abundantly clear within the contract. It highlights the party's intent to have a remedy in place for certain breaches. Defined scope. The clause specifies the scope of indemnification, defining the types of losses, costs, or liabilities for which the indemnitor is responsible. This clarity helps prevent disputes over what is covered under the indemnification. Separate agreement. By explicitly creating an indemnification obligation, the clause creates a separate legal obligation that can be pursued as a distinct cause of action. This means the indemnitee can bring a legal claim based on the breach of the indemnification clause, even if the underlying breach of contract might have additional remedies. Legal framework. While contractual promises are legally enforceable, an indemnification clause reinforces the legal framework for indemnification. It provides the parties with a specific, agreed-upon mechanism for addressing and resolving issues related to breaches and losses. Predictable outcome. Parties can reasonably predict the outcome in the event of a breach. The indemnification clause assures the indemnitee of a particular course of action to recover losses, adding a layer of assurance beyond general contractual enforcement. In essence, the indemnification clause enhances the clarity, enforceability, and predictability of how breaches and resulting losses will be handled. While the contractual promises themselves are legally binding, the indemnification clause creates a specific remedy within the contract that parties can rely on, separate from the standard breach of contract remedies. Can you please provide a couple sample indemnification clauses that a person might find in a contract? Chat GPT. Certainly, here are a couple of sample indemnification clauses you might find in contracts. General Indemnification Clause. Indemnification Clause. Party A agrees to indemnify and hold harmless Party B, its officers, directors, employees, and agents from any and all claims, demands, losses, liabilities, costs, and expenses, including reasonable attorney's fees, arising out of or resulting from any breach of this agreement by Party A. Third-party claims indemnification clause. Indemnification clause. Party A shall indemnify and defend Party B against any third-party claims, actions, suits, or demands, including associated costs and legal fees, arising from the use of Party A's products by Party B, provided that Party B promptly notifies Party A in writing of such claims and cooperates in the defense. Please note that the language and specific terms in indemnification clauses can vary widely based on the nature of the contract and the parties involved. These are simplified examples, and actual clauses should be carefully drafted and tailored to the specific circumstances and risks addressed in the contract. Legal advice is often recommended when including indemnification clauses in contracts to ensure they comply with applicable laws and effectively manage risk. Can you provide a glossary of key terms, with simple definitions, such as indemnify, hold, harmless, defend, shifting risk, and other terms used in the answers above? Chat GPT. Certainly. Here's a glossary of key terms related to indemnification and other concepts discussed in previous answers, along with simple definitions. Indemnify. Definition: to promise to protect and compensate another party if certain problems or losses occur. Hold harmless. Definition: to promise to ensure that another party does not suffer harm or financial detriment due to specified issues covered in a contract. Defend, in the context of indemnification. Definition: to take responsibility for the legal defense of another party in case of claims or legal actions related to specified events, covering legal costs and handling the defense process. Shifting risk. Definition: the act of transferring or allocating financial responsibility for specific risks or liabilities from one party to another, often through indemnification clauses in contracts. Risk identification. Definition: the process of identifying and understanding potential risks or threats that a business or organization may face, which is a crucial step in risk management. Risk mitigation. Definition: the process of reducing the likelihood or impact of identified risks to protect an organization from potential harm or financial losses. Limitation on damages. Definition: a provision in contracts that sets a maximum amount or cap on the financial liability of one party, limiting their responsibility for potential losses or claims. Transit, in the context of indemnification. Definition: the process of moving from traditional, one-sided indemnification clauses to more balanced and mutually agreeable provisions in contracts. Evolving trends, in indemnification clauses. Definition: changing practices and approaches in the drafting and negotiation of indemnification clauses in contracts, often reflecting a shift toward more balanced and reasonable provisions. Risk management. Definition: the process of identifying, assessing, and addressing risks to minimize the likelihood and impact of adverse events on an organization. Contract negotiation. Definition: the process of discussing, revising, and finalizing the terms and conditions of a contract between parties to ensure mutual agreement and clarity. Risk allocation. Definition: the assignment of responsibility for potential financial losses or liabilities between parties in a contract, often through indemnification clauses. Please note that these definitions provide simplified explanations and do not encompass the full legal or technical scope of these terms. The understanding and usage of these terms may vary based on specific contexts and industries. Can you please write a paragraph or two about each of the items under key elements of indemnification clauses? Chat GPT. Certainly, here are paragraphs elaborating on each of the key elements of indemnification clauses. 2. Key elements of indemnification clauses. A. Identification of parties. In an indemnification clause, it's crucial to clearly identify the parties involved. This typically includes the indemnifying party, the party offering indemnification, and the indemnified party, the party receiving protection. Clarity in party identification helps prevent confusion and disputes regarding who is responsible for indemnifying whom. The scope of indemnification. The scope of indemnification defines what types of claims, losses, or liabilities are covered by the clause. Parties must specify whether it includes damages resulting from breaches of contract, third-party claims, or specific events. Careful consideration of the scope is essential to ensure that it adequately addresses the parties' intentions and concerns. See triggering events. This element outlines the conditions under which the indemnification obligation is activated. Common triggering events include breaches of representations or warranties, violations of specific terms in the contract, or third-party claims. Defining these trigger events precisely is vital for clarifying when indemnification becomes applicable. De-indemnification process. The indemnification process describes how the parties should handle claims and liabilities covered by the clause. It typically includes provisions for notification, defense, settlement, and payment procedures. Clarity in the indemnification process ensures that both parties understand their obligations and can efficiently manage potential claims. Limitations and exclusions. Indemnification clauses often include limitations and exclusions to define the boundaries of the indemnification obligation. Common limitations may cap the amount of indemnification, specify time limits for making claims, or exclude certain types of damages. These limitations and exclusions are essential for managing risk and preventing excessive indemnification obligations. Each of these elements plays a critical role in shaping the indemnification clause, and their careful consideration during contract drafting is essential to ensure that the clause serves the interests of both parties while minimizing the potential for disputes. Please draft a few indemnification clauses illustrating clear indemnification clauses followed by an explanation after each clause. Chat GPT. Certainly, Here are a few indemnification clauses along with explanations of their key components. General Indemnification Clause. Indemnification Clause Explanation. This clause is a basic indemnification provision. It specifies that Party A, the indemnitor, agrees to indemnify and hold harmless Party B, the indemnitee, from any and all claims, losses, and liabilities arising from the breach of any representations or warranties made by Party A in the contract. The clause is clear in identifying the parties, scope, breach of representations or warranties, and the triggering event, breach, making it a straightforward indemnification provision. Third-party claims indemnification clause. Indemnification clause explanation. This clause extends the indemnification obligation to third-party claims. It states that Party A will indemnify Party B against any claims, suits, or actions brought by third parties that arise due to Party A's actions or omissions. It provides a clear scope, third-party claims, a broad triggering event, claims brought by third parties, and highlights the importance of Party A's responsibility for any legal defense costs incurred by Party B. Limitation on damages indemnification clause. Indemnification clause explanation. This clause introduces a limitation on damages. It specifies that Party A's indemnification obligation is limited to a maximum amount, which is often an important consideration for managing risk. This limitation is especially relevant when the potential losses are substantial. While it provides protection, it also prevents excessive indemnification obligations. Notification and Defense Indemnification Clause. Indemnification Clause explanation. This clause outlines the indemnification process. It mandates that Party B must promptly notify Party A of any claims that might lead to indemnification. It also requires Party A to take over the defense of such claims, including the right to settle. The notification and defense provisions are crucial in ensuring a smooth process for handling claims, as they define the steps each party must take. Exclusion of consequential damages indemnification clause. Indemnification clause explanation. In this clause, Party A excludes the indemnification of consequential or special damages. This limitation is beneficial when parties want to exclude indirect or speculative losses from the indemnification scope. It clarifies that Party A is not responsible for claims related to such damages, which can help manage expectations and prevent disputes. These example indemnification clauses showcase different aspects of indemnification, including scope, limitations, third-party claims, and the indemnification process. When drafting or reviewing such clauses, it's essential to ensure clarity and alignment with the parties' intentions, as well as compliance with applicable laws and regulations. Please provide an explanation or examples of the common issues with indemnification. Chat GPT. Common issues with indemnification clauses can lead to disputes and challenges in contracts. Here are some explanations and examples of these issues. Ambiguity and interpretation. Issue: vague or poorly drafted indemnification clauses can lead to disputes over their interpretation. Example: an indemnification clause stating that Party A will indemnify Party B for any losses without specifying the types of losses or circumstances can lead to disagreements about what losses are covered. Misaligned interests. Issue: parties may have conflicting interests in indemnification, where one party seeks broad coverage while the other wants to limit exposure. Example: Party A, a service provider, may want to limit its indemnification obligations, while Party B, a client, may push for broader coverage, resulting in negotiation challenges. Third-party claims. Issue: determining when and how to indemnify for third-party claims can be complex, as it involves external parties not directly involved in the contract. Example: Party A is sued by a third party for intellectual property infringement related to the services it provides to Party B. Deciding whether Party B should be indemnified for this claim can be contentious. Governing law and jurisdiction. Issue: differences in applicable laws and jurisdictions can affect the enforcement of indemnification clauses. Example: if Party A is based in one country and Party B in another, disagreements may arise regarding which country's laws and courts should govern disputes related to indemnification. Indemnification amount and limits. Issue: determining the maximum indemnification amount or limits can be a contentious point of negotiation. Example: Party A may want to cap its indemnification liability at a specific dollar amount, while Party B may argue for a higher cap to ensure adequate protection. Notice requirements. Issue: failure to comply with notice requirements can hinder the indemnification process. Example: if Party B fails to promptly notify Party A of a potential claim that could trigger indemnification, Party A may dispute its obligation to indemnify due to a lack of timely notice. Change in circumstances. Issue: events or circumstances occurring after the contract is signed can complicate indemnification. Example: a new law is enacted that affects the services provided by Party A to Party B. This change can lead to disagreements about whether Party A should indemnify Party B for any resulting legal challenges. Fraud or misrepresentation. Issue: proving fraud or misrepresentation as a triggering event for indemnification can be challenging. Example: Party B claims that Party A misrepresented its financial stability during contract negotiations. Party B seeks indemnification for financial losses but must provide evidence of fraudulent intent, which can be difficult. These issues highlight the complexities and potential pitfalls associated with indemnification clauses in contracts. It's crucial for parties to address these issues during contract negotiation and drafting to ensure clear, fair, and effective indemnification provisions. Under finding a fair balance in indemnification clauses, can you talk about the difference between indemnification for damage or injury on the one hand, and other kinds of indemnifications, especially from the perspective of the person who is paying for services? Chat GPT. Finding a fair balance in indemnification clauses is crucial, especially when distinguishing between indemnification for damage or injury and other forms of indemnification, primarily from the perspective of the party paying for services. Here's an explanation of this balance. Indemnification for damage or injury. When a party is providing services, they may be exposed to various risks, including the potential for causing damage or injury. In such cases, the party receiving the services, the client or beneficiary, often seeks indemnification to protect themselves against losses resulting from these specific risks. Example: Party A, a construction company, is hired to build a structure for Party B. Party B insists on indemnification for any physical injury or property damage caused by Party A's construction activities. This is a common and reasonable request, as it ensures that Party B is not financially burdened if an accident occurs. Other kinds of indemnification. In addition to damage or injury, there may be other types of indemnification sought by the party receiving services. These can include indemnification for breaches of contract, violations of regulations, intellectual property infringements, or other contractual obligations. Example: Party B, a software development company, requests indemnification from Party A for any third-party claims of patent infringement resulting from Party A's software. This broader indemnification extends beyond damage or injury and covers intellectual property issues. Balancing these different forms of indemnification requires considering the following. Proportionality: the indemnification obligation should be proportional to the actual risks involved. Demanding extensive indemnification for relatively minor breaches or risks may be seen as unfair. Parties should align indemnification with the potential harm. Clear definitions: the contract should clearly define the scope of indemnification for various types of risks. This clarity ensures both parties understand what is covered and can agree to reasonable terms. Cost considerations: the party providing the services should consider the financial implications of indemnification. Excessive indemnification demands can significantly impact their liability and costs. Negotiations should aim for a balance that is fair and sustainable. Mitigation and insurance: in some cases, parties can agree on alternative risk mitigation strategies or require the party providing services to maintain specific insurance coverage. This can help strike a balance between protecting the recipient and ensuring the service provider's financial stability. Legal and regulatory compliance: parties must also consider legal and regulatory requirements. Some indemnification obligations may be non-negotiable due to legal mandates, while others are open to negotiation. Finding a fair balance in indemnification clauses involves careful negotiation, a consideration of the specific risks, and an understanding of the financial implications for both parties. It's essential to tailor indemnification provisions to the unique circumstances of each contract while keeping fairness and reasonableness in mind. Can you please explain changes in indemnification practices? Chat GPT. Evolving trends in indemnification. Evolving trends in indemnification clauses reflect the changing landscape of business and legal practices. In recent years, there has been a shift towards more balanced and reasonable indemnification provisions. For a company with decreasing risk tolerance, it's important to stay updated on these trends. Many companies are moving away from overly broad indemnification requirements and adopting more precise and focused language to limit exposure. Example: instead of demanding indemnification for any and all claims, companies might specify that indemnification only applies to specific, foreseeable risks. As risk tolerance decreases, a company may transit from relying on overly protective indemnification clauses to ones that offer a fair allocation of risk between parties. Example: instead of having a standard indemnification clause in all contracts, the company may start negotiating more tailored provisions to better suit their risk appetite. Indemnification and changing practices. Indemnification practices are changing in response to legal developments, industry standards, and negotiation dynamics. Companies are increasingly cautious about excessive indemnification obligations. In light of this change, a company with lower risk tolerance may find that they have more leverage in contract negotiations. They can demand more balanced indemnification clauses without fear of losing opportunities. Example: the company may insist on capping indemnification liability at a reasonable amount and excluding certain types of damages, aligning with the changing trend of limiting exposure. The company should use its newfound selectivity to focus on contracts that offer reasonable indemnification terms and avoid agreements with overly onerous clauses. Example: the company might decide to only engage with vendors and partners who are willing to negotiate and adapt their indemnification provisions to better match the company's risk appetite. This approach can lead to more balanced and sustainable business relationships. As companies become more granular in their approach to intellectual property and emerging businesses heavily rely on certain IP, indemnification clauses in contracts can become more critical and nuanced. Here are two sample indemnification clauses, one generic and one detailed, related to intellectual property. Generic intellectual property indemnification clause. Indemnification clause. Party A shall indemnify and hold harmless Party B against any claims, actions, suits, or demands arising from alleged or actual infringement of third-party intellectual property rights as a result of Party A's products, services, or deliverables provided under this agreement, provided that Party B promptly notifies Party A in writing of such claims and cooperates in the defense. Party A's indemnification liability shall be limited to the total contract value or dollar, whichever is lower. Detailed intellectual property indemnification clause with IP allocation. Indemnification clause. Party A and Party B acknowledge and agree to a detailed allocation of intellectual property rights as follows. A. Party A shall retain all rights, title, and interest in any pre-existing intellectual property utilized in providing services under this agreement. B. Any new intellectual property created specifically for Party B under this agreement shall be jointly owned by Party A and Party B, with shared rights and responsibilities for protection and enforcement. C. Party B shall have a non-exclusive, royalty-free, worldwide license to use, modify, and sublicense the new intellectual property solely for its internal purposes and in connection with the services provided under this agreement. D. Any pre-existing intellectual property provided by Party B and used by Party A in the services shall remain the property of Party B, and Party A shall have a non-exclusive, limited license for the duration of this agreement to use such intellectual property solely for the provision of services. In the event of any claims or legal actions asserting infringement of third-party intellectual property rights related to the jointly owned intellectual property as outlined in Section 1B above, Party A and Party B shall cooperate in the defense, and Party A shall bear the costs of legal defense, settlements, and any damages awarded. Party A shall indemnify and hold harmless Party B against any claims, actions, suits, or demands arising from alleged or actual infringement of third-party intellectual property rights related to the services provided under this agreement, provided that Party B promptly notifies Party A in writing of such claims and cooperates in the defense. Party A's indemnification liability shall be limited to the total contract value or dollar, whichever is lower. The second clause offers a detailed allocation of intellectual property rights between the parties, making it clear how the jointly created IP is managed and protected, as well as the responsibilities in case of third-party infringement claims. It's essential to consult legal experts to ensure that such detailed clauses align with specific legal and business requirements. How is identification related to risk mitigation? Chat GPT. Identification is a crucial step in the risk mitigation process. In the context of risk management, risk identification refers to the process of identifying, assessing, and understanding potential risks or threats that a business or organization may face. Once these risks are identified, organizations can develop strategies and measures to mitigate or manage them effectively. Here's how risk identification relates to risk mitigation. Identification is the starting point. Risk identification is the initial step in the risk management process. It involves systematically identifying and cataloging potential risks, including financial, operational, legal, and strategic risks. Without proper identification, an organization cannot effectively address or mitigate risks. Understanding risk exposure. Identifying risks helps organizations understand the extent of their exposure. By recognizing the specific risks they face, organizations can assess the potential impact on their operations, reputation, and financial stability. Prioritization of risks. After identification, organizations often prioritize risks based on their likelihood and potential impact. High-priority risks are the ones that pose the most significant threats and are, therefore, the focus of mitigation efforts. Mitigation strategy development. Once risks are identified and prioritized, organizations can develop mitigation strategies. These strategies may include risk avoidance, risk reduction, risk transfer, for example, through insurance or acceptance, with a contingency plan in place. The choice of strategy depends on the nature of the risk and the organization's risk appetite. Customized mitigation approaches. Effective risk mitigation strategies are tailored to the specific risks identified. For example, if a company identifies cybersecurity threats as a high-risk area, its mitigation strategy may involve strengthening IT security measures, training employees on cybersecurity best practices, and having a response plan in case of a breach. Continuous monitoring and adaptation. Risk identification is not a one-time process but an ongoing one. As the business environment evolves, new risks may emerge, and existing risks may change. Organizations must continually monitor and adapt their risk mitigation strategies based on updated risk assessments. In summary, risk identification is the foundation of effective risk mitigation. By recognizing and understanding potential risks, organizations can develop and implement strategies to reduce the likelihood and impact of these risks. It's a dynamic and iterative process that helps organizations proactively manage uncertainty and protect their interests. What is the role of indemnification in modern business practices? For example, take the scenario of $5,000 of services with an error that resulted in $1 million claim. Chat GPT. Indemnification plays a significant role in modern business practices by providing a mechanism for risk allocation and protection against financial losses. In the scenario you mentioned, where $5,000 of services resulted in a $1 million claim due to an error, indemnification can serve several vital functions. Risk transfer and protection. Indemnification clauses are commonly used in contracts to shift the financial burden of potential liabilities from one party to another. In this case, the party providing the services, the indemnitor, might have agreed to indemnify the other party, the indemnity, against claims arising from errors or negligence. This shifts the risk and potential financial loss from the indemnity to the indemnitor. Financial security. For the indemnity, the indemnification clause offers financial security. In the scenario, the $1 million claim is substantial and could have severe financial implications. Indemnification allows the indemnity to seek compensation from the indemnitor, ensuring they don't bear the entire financial burden. Risk management. Indemnification serves as a risk management tool. It encourages the party responsible for a specific error or negligence to take measures to prevent such incidents and, if they occur, to rectify them promptly. This incentivizes the indemnitor to maintain quality standards in their services. Legal protection. Indemnification clauses often outline the legal process for addressing claims and disputes. They provide a framework for how claims should be handled, including notice requirements, defense procedures, and potential settlements. This legal protection ensures that disputes are managed systematically and fairly. Negotiation tool. In contract negotiations, indemnification terms can be a point of discussion. Parties can negotiate the scope of indemnification, the financial limits, and other conditions. This negotiation allows for a fair allocation of risk, especially in cases where the potential liability far exceeds the contract value, as in the scenario. Insulation against catastrophic losses. For the party offering indemnification, they may secure insurance or financial resources to cover potential indemnification obligations. This insulation helps prevent catastrophic financial losses that could otherwise threaten the viability of their business. In summary, indemnification in modern business practices serves as a critical risk management and financial protection tool. It allocates and manages risk, provides financial security, encourages responsible behavior, and helps resolve disputes. In cases where a relatively small contract value leads to a substantial claim, indemnification can be the difference between financial stability and severe financial consequences for the parties involved. Can you provide any other real-world examples? Chat GPT. Certainly, here are a few real-world examples of the role of indemnification in modern business practices. Real estate transactions. In real estate deals, buyers may request indemnification from sellers for potential hidden defects or encumbrances in the property. For instance, if a buyer discovers environmental contamination on a property after purchase, they may seek indemnification from the seller to cover the cost of cleanup. Software and technology contracts. In software and technology agreements, vendors often provide indemnification to their customers. If the software or technology infringes on third-party intellectual property rights, the vendor may be responsible for covering legal expenses and damages resulting from lawsuits. Merger and acquisition agreements. In M&A deals, the acquiring company might demand indemnification from the selling company for any undisclosed or hidden liabilities or legal claims that surface after the acquisition. This ensures that the buyer is protected from unforeseen financial risks. Supply chain contracts. Companies in the supply chain often use indemnification clauses to allocate risk. For example, a manufacturer may seek indemnification from a component supplier for any defects in the supplied parts that result in product recalls or safety issues. Professional services contracts. In contracts with professional service providers, such as consultants or legal advisors, clients may request indemnification for errors, omissions, or negligence in the services provided. This protects clients from financial losses resulting from professional mistakes. Product liability and recalls. Manufacturers may seek indemnification from suppliers if a product recall is initiated due to a component defect. This indemnification ensures that the supplier shares the financial burden of the recall, including costs related to replacement and potential legal claims. Construction contracts. In the construction industry, indemnification clauses are commonly used. General contractors often require subcontractors to indemnify them against claims arising from the subcontractor's work, such as accidents or defects in construction. These real-world examples illustrate how indemnification serves as a risk management and financial protection tool in a wide range of industries and contractual relationships. It allows parties to allocate and manage potential liabilities, providing a degree of security and fairness in business dealings. Are there ever indemnification obligations imposed by other areas of law, such as legislation or common law? Or is indemnification generally a contractual term only? Chat GPT. Indemnification can arise from both contractual terms and other areas of law, such as legislation or common law. Here are some ways in which indemnification obligations can be imposed. Contractual agreements. The most common source of indemnification obligations is through contracts. Parties can include indemnification clauses in their agreements to specify the terms under which one party agrees to indemnify and protect the other. Legislation. Certain laws or regulations may require indemnification. For example, in some jurisdictions, laws related to environmental protection may impose indemnification obligations on companies responsible for pollution or hazardous waste cleanup. Statutes and regulations. In some industries, specific statutes and regulations mandate indemnification. For instance, laws related to product liability may impose obligations on manufacturers to indemnify parties harmed by defective products. Common law. Common law principles, which are based on court decisions and legal precedents, can establish indemnification obligations. Courts may recognize implied indemnification in certain situations where one party is deemed responsible for another party's losses. Tort liability. Tort law, which addresses civil wrongs and negligence, can lead to indemnification obligations. For example, if one party's negligence causes harm to another, the negligent party may be required to indemnify the injured party for their losses. Insurance contracts. Indemnification is a fundamental concept in insurance. Insurance policies often include provisions where the insurer agrees to indemnify the insured party against covered risks. Agency or employment relationships. In the context of agency or employment relationships, one party may have a duty to indemnify the other for legal claims arising from actions taken within the scope of the agency or employment. In summary, indemnification obligations can originate from various sources, including contracts, legislation, regulations, common law, and specific legal contexts. These obligations are not limited to contractual terms alone and can be imposed or recognized by other legal mechanisms. The specific nature and scope of indemnification can vary widely based on the applicable laws and circumstances. Based on your answers, please provide some review questions that I should be able to answer. Chat GPT. Certainly, here are some review questions related to the role of indemnification in modern business practices and the concepts discussed. What is the primary role of indemnification clauses in contracts, and how do they contribute to risk management? In the context of indemnification, what is the significance of risk identification, and how does it relate to risk mitigation? Explain the concept of transit and indemnification practices and how it can be relevant to businesses with decreasing risk tolerance. How can indemnification help protect a company from financial losses in a scenario where $5,000 of design services results in a $1 million claim due to an error? Provide examples of real-world scenarios where indemnification plays a crucial role in mitigating risks and protecting parties involved in various types of contracts. What are some common issues and challenges associated with indemnification clauses, and how can these challenges be addressed or prevented in contract negotiations? In the context of indemnification, explain the concept of limitation on damages. How does it benefit the party that may be responsible for indemnification? How do changing trends in indemnification clauses reflect evolving practices in business contracts? Why is it important for businesses to stay updated on these trends? In a scenario where a company's risk tolerance is decreasing, what considerations should the company make when negotiating indemnification clauses in contracts? What is the relationship between indemnification and risk allocation in contracts? How does it help parties allocate responsibility and financial liability effectively? These review questions should help you assess your understanding of indemnification and its role in modern business practices, as well as the various concepts discussed in the previous explanations. Please provide a series of indemnification clauses. Chat GPT. Certainly, here are a series of indemnification clauses, each with a different focus and scenario. Standard indemnification clause. Indemnification clause. Party A agrees to indemnify and hold harmless Party B from any and all claims, damages, losses, liabilities, and expenses arising out of or related to Party A's breach of any representation or warranty in this agreement. Third-party claims indemnification clause. Indemnification clause. Party A shall indemnify Party B against any claims, actions, suits, or demands brought by third parties resulting from the use of Party A's products or services, provided that Party B promptly notifies Party A of such claims and cooperates in the defense. Limitation on damages indemnification clause. Indemnification clause. Party A's indemnification liability shall be limited to the total contract value or dollar, whichever is lower. This limitation applies to all claims, including but not limited to breach of contract, negligence, or any other cause of action. Notification and defense indemnification clause. Indemnification clause. In the event of a claim or liability that could trigger indemnification, Party B shall promptly notify Party A in writing. Party A shall assume responsibility for the defense, settlement, and resolution of such claims, with the right to choose legal counsel. Exclusion of consequential damages indemnification clause. Indemnification clause. Notwithstanding anything to the contrary, Party A shall not be liable for any indirect, consequential, or special damages, whether based on contract, tort, or otherwise, even if Party B has been advised of the possibility of such damages. Intellectual property indemnification clause. Indemnification clause. Party A warrants that its services do not infringe on any third-party intellectual property rights. Party A shall defend, indemnify, and hold Party B harmless from any claims or actions alleging intellectual property infringement. Environmental liability indemnification clause. Indemnification clause. Party A acknowledges that its operations on Party B's premises may pose environmental risks. Party A shall indemnify and hold Party B harmless from any environmental damage, cleanup costs, or regulatory fines arising from Party A's actions. Indemnification for professional services clause. Indemnification clause. Party A, a professional services provider, shall indemnify Party B for any losses, damages, or liabilities resulting from errors or omissions in the professional services provided by Party A, subject to a maximum liability cap of $. Indemnification for product liability clause. Indemnification clause. Party A, the manufacturer of products supplied to Party B, agrees to indemnify and defend Party B against claims, injuries, or losses arising from product defects, malfunctions, or injuries caused by Party A's products. Indemnification in Construction Contracts Clause. Indemnification Clause. Subcontractor, Party A, shall indemnify, defend, and hold harmless general contractor, Party B, from any claims, losses, or liabilities arising from accidents, injuries, or property damage resulting from subcontractors' construction activities on the project site. Please note that these are example clauses and should be adapted to the specific needs and legal requirements of each contract. Legal counsel or experts should be consulted when drafting or modifying indemnification clauses in real contracts. Please reiterate the practical distinction between to indemnify and hold, harmless, and why an indemnification clause might include both terms, and also please distinguish the indemnification to defend. Chat GPT. Certainly, let's clarify the practical distinctions between to indemnify and to hold harmless in indemnification clauses, and how to defend is distinct as well. To indemnify. To indemnify means that one party, the indemnitor, agrees to compensate or make another party, the indemnity, whole for specific losses, damages, or liabilities. This typically includes covering financial losses incurred by the indemnity as a result of certain events or claims. Example, Party A agrees to indemnify Party B for any financial losses Party B incurs due to third-party claims resulting from a product defect. To hold harmless. To hold harmless is often used interchangeably with to indemnify. It means that the indemnitor not only agrees to compensate the indemnity for losses but also assures that the indemnity will not suffer any harm or financial detriment as a result of the specified events or claims. Example, Party A agrees to hold Party B harmless for any financial losses or harm resulting from third-party claims due to a product defect, including both terms. In some indemnification clauses, both terms to indemnify and hold harmless are used to provide a comprehensive level of protection to the indemnity. By including both terms, the indemnitor not only compensates the indemnity for losses but also guarantees that the indemnity will not be adversely affected by the events or claims covered by the indemnification. Example, Party A agrees to indemnify and hold harmless Party B for any claims, losses, damages, or harm resulting from third-party claims due to a product defect. To defend. To defend in an indemnification clause means that the indemnitor assumes responsibility for the legal defense of the indemnity in case of claims or legal actions related to the specified events. This typically includes providing legal counsel, covering legal expenses, and handling the defense process. Example, Party A agrees to defend, indemnify, and hold harmless Party B in any litigation brought by third parties related to the product defect, covering all legal costs. In summary, to indemnify and to hold harmless are often used interchangeably, with the latter emphasizing a commitment to ensure the indemnity is not harmed. Including both terms offers a comprehensive level of protection. To defend goes a step further by specifically addressing the legal defense aspects of indemnification, ensuring that the indemnity is not only compensated but also protected from legal costs and liabilities related to the covered events or claims.